quorum be suspended.
Without objection.
Mr. President, I know we're in morning business. I asked to speak on the nomination of James Cole to be Deputy Attorney General. I rise in opposition to the motion to invoke cloture on the nomination of James Cole to be Deputy Attorney General at the Department of Justice. I oppose proceeding to a vote on the nominee for a number of reasons. I've been concerned regarding Mr. Cole's qualifications and am troubled by President Obama's recess appointment of Mr. Cole to this position. I have been consistent in my opposition to recess appointments over the years that I was chairman of the Senate Finance Committee, and under a Republican president, I had this same rule in mind. When the President bypasses the Senate by making recess appointments, such nominees will not receive my support. We have a process in place for nominations, and if the President isn't willing to work with senators to clear nominations, the nominee shouldn't get a second bite at the apple. In addition to my general opposition to recess appointments, I have consistently warned this administration that I would not cooperate in moving nominees from the Department of Justice until they cooperate with my request for oversight materials. Last month, I went to the floor to describe what I have learned in the course of my investigations into whistleblower allegations at the Bureau of Alcohol, Tobacco, Firearms, and Explosives. According to whistleblowers, guns found at the scene of the murder of Border Patrol Agent Brian Terry had been purchased illegally by known straw buyers a year earlier with the blessing of the ATF as part of an operation known as Fast and Furious. I first asked about this issue on January the 27th. On February the 16th, I requested specific documents from the Justice Department. I reiterated that request on March the 3rd. When the Justice Department failed to produce any responsive documents, I partnered with the House Oversight and Government Reform Chairman Darrell Issa, who first requested documents and then issued a subpoena to the ATF after his voluntary request was ignored. On February the 13th, my staff learned that the Justice Department was making certain documents available for Chairman Issa's staff to review at the Department. Not only did the Department fail to notify me of this document review when I sent two of my staff members to participate in this, they were turned away at the door of the Justice Department. To this day, the Justice Department has still not produced a single page of documents in response to my inquiries and has provided only previously released documents in response to Chairman Issa. I received a letter on May 2 this year declining to provide my staff with access to the documents on the grounds that, quote, the executive branch has taken the position that only a chairman can speak for the committee in conducting oversight work, end of quote. Now, I'd like to quote from the District of Columbia Circuit Court of Appeals on this issue. Quote, it would be an inappropriate intrusion into the legislative sphere for the court to decide without congressional direction that, for example, only the chairman of a committee shall be regarded as the official voice of the Congress for the purposes of receiving such information as distinguished from its ranking minority member, other committee members, or other members of Congress. Each of them participates in the lawmaking process. Each has a voice and a vote in that process, and each is entitled to request such information from the executive agencies as will enable him to carry out the responsibilities of a legislator, end of quote, and that's from Murphy versus the Department of the Army, 1979. I said on the floor on April the 14th this year that if the Justice Department did not cooperate and provide the information we need, I would consider exercising my right to object to unanimous consent requests on a nomination. Since that time, I have received nothing but stonewalling from the Department. As the Chief Operating Officer of the Department, Mr. Cole is in a position to ensure the Justice Department meaningfully cooperates with my inquiries and complies with my document requests. He has failed to do so. I also am troubled by the Department's continued resistance to oversight requests from Senator Chambliss, Vice Chairman of the Select Committee on Intelligence. Senator Chambliss has requested the Department of Justice share important documents with Congress regarding the Guantanamo Bay Detainee Review Task Force. This task force reviewed the case files of many detainees that were released or transferred from U.S. custody. Unfortunately, we now know that over 25% of those detainees later returned to fight against America or our allies. These documents are part of a legitimate exercise of our constitutional duty to conduct oversight. The Department's repeated stonewalling of Senator Chambliss's request should not be rewarded with a cloture vote on a controversial nominee. The Deputy Attorney General is second in command at the Justice Department and responsible for overseeing the day-to-day operations of the Department. Managing this vast bureaucracy is a difficult task that requires a serious commitment to protecting our national security, enforcing our criminal laws, and safeguarding taxpayer dollars. We need a qualified individual to fill this slot, an individual who possesses the ability not only to provide leadership for the Department, but also an individual who has the smarts, the capability, and the willingness to manage Department programs and root out inefficiencies and abuse in these programs. After reviewing all those responses and his hearing testimony, I concluded that I could not support Mr. Cole's nomination to be Deputy Attorney General. In particular, I'm seriously concerned about Mr. Cole's views on national security and terrorism. Back in 2002, Mr. Cole was author of an opinion piece in Legal Times. In that piece, he stated, quote, "For all the rhetoric about war, the September 11 attacks were criminal acts of terrorism against a civilian population, much like a terrorist acts of Timothy McVeigh and blowing up the federal building in Oklahoma City or Omar Abdel Rahman in his first efforts to blow up the World Trade Center. The criminals responsible for these horrible acts were successfully tried and convicted under our criminal justice system without the need for special procedures that altered traditional due process rights," end of quote. But he went on to say this, quote, "The acts of September 11th were horrible, but so are other things," end of quote. The other things he referred to were drug trade, organized crime, rape, child abuse, and murder. Mr. Cole's opinion piece argued that notwithstanding the involvement of foreign organizations such as al-Qaeda, we have never treated criminal acts influenced by foreign nationals or governments as a basis for, quote, "ignoring the core constitutional protections ingrained in our criminal justice system," end of quote. Mr. Cole concludes his opinion piece by arguing that in addition to stopping future terrorist attacks, the Attorney General is a criminal prosecutor and that he has a special duty to apply constitutional protections ingrained in our criminal justice system to everyone, including terrorists captured on foreign battlefields. Mr. Cole wrote this opinion piece 2 days short of the first anniversary of the September 11th attacks. Given the close proximity in time to the September 11th attacks, we must understand this opinion piece to be Mr. Cole's true beliefs about the application of the civilian criminal justice system to terrorism cases, including those who masterminded the 9/11 attacks. From the opinion piece and his responses to our inquiries, it appears that if given a choice of prosecuting high-ranking terrorists in civilian courts or military commissions, Mr. Cole would likely favor civilian courts based upon his long-standing belief in the role the Attorney General plays in protecting the principles of the criminal justice system. Absent a clear statement from Mr. Cole about what factors would warrant selecting a civilian or military form, it is hard to look at his entire record of past opinions, his testimonies, and responses to our questions and reach a different conclusion. Military tribunals have many advantages to civilian criminal courts and are better equipped to deal with dangerous terrorist and classified evidence while preserving due process. I'm troubled that Mr. Cole does not appear to share this belief. Based upon his responses and testimony, I have serious doubts about Mr. Cole's support for civilian trials for terrorists captured on foreign battlefields, given that the Deputy Attorney General oversees the National Security Branch of the Justice Department. Second, I have concerns about Mr. Cole's ability relative to oversight of government programs. First, in his responses about this oversight of DOJ grant programs, Mr. Cole failed to commit to a top-to-bottom review of the programs. We've had enough examples of the tremendous inefficiencies, duplications, and waste in these programs. I'm disappointed that Mr. Cole has failed to recognize that there is a need for comprehensive review of the Department of Justice's grant program, not only for the sake of saving taxpayers' dollars, but also to ensure that grant objectives are being met in the most efficient and effective manner possible. Third, I do not have confidence regarding Mr. Cole's abilities based on his performance as an independent consultant tasked with overseeing AIG. By the way of background, the Justice Department provided copies of the reports Mr. Cole issued when he was overseeing AIG, but they were labeled, quote, committee confidential, end of quote. Consequently, I cannot discuss in a specific manner the context of those documents publicly. Nevertheless, when taken into context with the public responses provided by Mr. Cole to my questions, a troubling picture develops about Mr. Cole's performance in his independent consultant responsibilities. The responses and reports do not dispel the serious questions raised about Mr. Cole's independence and completeness. Further, they reveal what appears to be a level of deference to AIG's management one would not expect to see from someone tasked as, quote, unquote, independent monitor. In order to clarify a number of questions on this matter, Senator Coburn and I sent a follow-up letter seeking additional answers from Mr. Cole. Mr. Cole's reply clarified that DOJ, SEC, and the New York State Attorney General's office were aware of his practice of seeking input from AIG and making modifications to the report. He indicated that the changes AIG made were often factual changes, such as AIG employee names, dates of materials, and events. He also indicated that some of the changes requested by AIG were included in a section of the report entitled, quote, unquote, AIG response. However, he said that, quote, unquote, on a few occasions, AIG would, quote, suggest a stylistic change of phrasing in the analytical section of the report, end of quote. He stated that while he included the edits made by AIG, he, quote, did not believe that a detailed presentation of this factual review process was necessary to an understanding of each party's position, end of quote. As a result, the report did not necessarily show which edits AIG made that were incorporated. Instead, he said that those changes were available in working papers that were, quote, available to the SEC, the DOJ, the New York Attorney General's office, end of quote. Unfortunately, he added that, quote, the agencies which were aware of this practice did not request such documents, end of quote. While I appreciate Mr. Cole's responses to these clarifying questions, they raise concerns about how independent his monitoring was, what changes were ultimately requested by AIG, what changes were included, and how much the SEC and the DOJ really knew about edits AIG was making to the independent reports. Finally, I have serious concerns about Mr. Cole's decision to suspend the compliance review at AIG's Financial Products Division following the government bailout. In his testimony, Mr. Cole acknowledged that following the government bailout of AIG, he scaled back his efforts until the future of AIG as a corporation was determined. After Mr. Cole suspended his monitoring, AIG restructured its compliance office and terminated a number of staff overseeing the company's compliance with the Securities and Exchange Commission regulations. Mr. Cole said that after it was determined that AIG's Financial Products Division would not be dissolved, the compliance and monitoring were, quote, revived and are being reviewed and implemented where applicable, end of quote. Under Mr. Cole's watch, AIG not only got $182 billion of taxpayers' money, it was able to talk the independent consultant, Mr. Cole, out of monitoring what the company was doing. Based upon these factors, I am concerned about Mr. Cole's ability to perform the duties required of Deputy Attorney General. In the position, he would be in a position to potentially influence future compliance monitors appointed under settlements between the Justice Department, the Securities and Exchange Commission, and other corporations that have violated the law. Independent monitors need to be truly independent and completely transparent. They are selected and appointed to ensure that the interests of the American people are protected. I cannot support the nomination of Mr. Cole to be Deputy Attorney General and therefore will vote against cloture. I urge all of my colleagues to join me in opposing this cloture vote to send a message to the Justice Department to stop the stonewalling of legitimate oversight inquiries from members of the United States Senate. I yield the floor.
Morning business is closed. Under the previous order, the Senate will proceed to executive session to consider the following nomination, which the clerk will now report.
Nomination, Department of Justice, James Michael Cole of the District of Columbia to be Deputy Attorney General.
Under the previous order, there will be 1 hour of debate, equally divided and controlled between the two leaders or their designees.
President, I would yield 10 minutes to the senator from North Carolina.
I thank the senator. Mr. President, in less than an hour, this body will be asked to vote on cloture to proceed to the nomination of James Cole as Deputy Attorney General. I rise in opposition to that cloture vote on the nomination of James Cole, and I urge my colleagues to strongly oppose that. As a member of the Senate Intelligence Committee, I share the views of the Vice Chairman, Senator Chambliss, and the ranking member of the Judiciary Committee, Senator Grassley, as expressed in their letter to Republican colleagues dated May 6, 2011, opposing cloture on this nomination. Mr. President, I would ask unanimous consent at this time to enter this letter into the record.
Without objection.
Mr. Cole's nomination is troubling on several fronts. First, the Department of Justice, where he now serves as a second-in-command since his recess appointment this past December, refuses to provide the Senate Intelligence Committee with documents we have been requesting for months. More than 2 years ago, the intelligence community learned that the recidivism rate, the number of prisoners that we release that go back into the fight at Gitmo, had raised to 11%. Today, it stands at over 25%. In his effort to close the detention facility at Gitmo, the President ordered a task force run by the Attorney General to review the status of all detainees still housed at Gitmo. Through much of 2009, the Gitmo Detainee Review Task Force examined every detainee's case and made recommendations to the administration on whether to transfer, release, or detain each one. At a time when Congress is aware that former Gitmo detainees are returning to their old ways, we have an obligation to the American people, to make sure that no more detainees are released who could cause us harm. Even though Gitmo remains open right now, efforts to transfer or release many of these detainees continue today. The documents the Intelligence Committee is seeking all relate to the task force process and will help the committee understand why the task force made the recommendations it did, especially with respect to those detainees who may have raised red flags by the intelligence community. We know that the Attorney General provided recommendations on how the task force should make its transfer decisions because of separate information provided to the committee. We do not have everything, however, including a September 2009 memorandum in which the Attorney General reportedly recommends that an entire category of detainees be presumed to be eligible for transfer. Presumed eligible for transfer. While we've asked for these memorandums and any other recommendations repeatedly, the department's refused to provide them. If the Attorney General of the United States recommended that certain detainees be treated favorably, possibly in spite of the intelligence, the Senate Intelligence Committee has a clear oversight interest in reviewing the September memorandum and seeing if and to whom it was applied. In addition to refusing to provide the September 2009 memorandum, the Justice Department has also denied the Intelligence Committee the recommendations of the task force. The committee cannot determine why the task force made its recommendations without seeing the description of how the task force came to the positions it did. The department claims that both the September 2009 memorandum and the unredacted recommendations are protected from disclosure to Congress because of a deliberative process. Well, Mr. President, this is an assertion ordinarily used in a FOIA case or in the context of executive privilege not to inhibit congressional oversight of a federal agency. An interesting inconsistency in this assertion is that the administration has willingly provided the Intelligence Committee with the recommendations of the past administrations. I understand that in the last few days, the Attorney General has reached out to the Vice Chairman of the Intelligence Committee in an effort to resolve these issues before today's vote. Given the Department's months of delays and obstruction in complying with this request, I believe cloture on this nomination is not appropriate until the documents requested have been provided in full. In addition to the document issue, Mr. Cole has not explained some highly charged comments he made about 9/11. An op-ed he authored back in September 2002 called the 9/11 attacks, and I quote, criminal acts of terrorism against the civilian population, unquote. He went on to dismiss the severity of 9/11, calling it no more than, and I quote, the scourge of the drug trade, the reign of organized crime, and countless acts of rape, child abuse, and murder, unquote. Mr. Cole has not rejected or fully explained those comments. Until he does so and until the Department ends its refusal to comply with reasonable congressional requests for information, I cannot support the move to consider his nomination, and I certainly urge my colleagues to reject that urge today. I thank the Chair. Suggest the absence of a quorum.
Clerk will call the roll.
Mr. Akaka.
I assume we're on the lights aren't on.
The Senate's in a quorum call.
Oh, the lights were not on. I'm sorry. I didn't. And then I'd ask consent for the quorum to be called off, and the lights are already off.
Without objection.
There are no lights on. President, I assume we're on the nomination of Jim Cole. You know, it's interesting, and Mr. President, time runs to, am I correct, make a parliamentary inquiry, time runs to 5:30?
The Senator's correct.
And the time has been consumed by this quorum call and subsequent quorum calls. I'd ask consent to be divided evenly between both sides.
Without objection.
Mr. President, the majority leader has been required to file cloture in this case. It's extraordinary. In an attempt to overcome a Republican filibuster for the nomination of Jim Cole to be the Deputy Attorney General. Now, this is a key national security position. The number 2 position in the Department of Justice. Certainly, what's happened the past week or so, you would think that if anything, if people really believed in national security, they would want this president or any president to have their full national security team. And I thought back and I said, I never remember a time in my 37 years here where the Senate's filibustered the president's nomination to be Deputy Attorney General. So I asked the Senate Judiciary Committee staff to check that. Their response was the Senate has never filibustered a president's nomination to be Deputy Attorney General. In fact, during the time I was chairman of the committee, we quickly moved each of President Bush's, former President Bush's, Deputy Attorney General, including a couple that certainly would not have been my choice, but we knew it was a national security position, and it was important at the time we face the threats we do here and abroad that we have that position filled. In fact, I thought it would be unconscionable, whether it's President Bush or President Reagan or any other president, to stall a Deputy Attorney General. And I might say, this nomination was blocked last year. A nomination was reported favorably by the Judiciary Committee again in March, and incredibly, it's again being filibustered. Somebody asked me, they said, this can't really be happening, can it? And I said, you know, it's 1 week after the successful operation that killed Osama bin Laden, the world's #1 terrorist, and there are people trying to block President Obama from having his full national security team in place. It's Alice in Wonderland. And now that a measure of justice has been secured for the victims of September 11th, I have expressed hope that we can come together as we did in the weeks and months following September 11th, and we should be ensuring that we're extra vigilant these days. There are widespread reports. Experts are concerned about this being a time in which al-Qaeda will seek reprisals. And most Americans believe we should be concerned about them trying to strike back. It's not a time for further delay or obstruction. We ought to join together and confirm this qualified nominee. We also ought to show the rest of the world that no matter what our political labels might be, we believe in the President of the United States having his national security team in place. This weekend, the Washington Post editorial board called this delay ridiculous, referring to the Deputy Attorney General as essentially the chief operating officer of the Justice Department, including its national security operations. Well, of course, the delay is ridiculous, but worse than ridiculous, it's dangerous to every single American. It makes us less safe. I hope other senators will see it as such and help end it. We have the opportunity to set aside partisanship and join with our President to keep America safe. I recall in the aftermath of 9/11, we took immediate steps, Republicans and Democrats together, to do what we could to make sure the President's entire law enforcement team was in place. We expedited nominations in the weeks and months that followed. We confirmed an additional 58 officials to post at the Justice Department those weeks and before the end of 2001. Today, apparently, they say, okay, that was good. You helped out a Republican president to get his security team in to protect the nation, but we're not going to help a Democratic president to get his security team in to help the nation. It's the same nation. The security threats are the same against Republicans and Democrats. We ought to come together as Americans first in this. Last week at the Judiciary Committee's oversight hearing on the Department of Justice, the Attorney General of the United States reiterated the need for final Senate action on the nomination of Deputy Attorney General. He urged the Senate to confirm Jim Cole to help the Department fulfill all of its critical tasks, including protecting national security in a time of heightened concern about retaliatory attacks stemming from Osama bin Laden's death. Yet, rather than take the action to end the unnecessary and unexplained delays, and finally confirm the nomination of Jim Cole, the unprecedented Republican filibuster continues. It's wrong. That should end. I hope the senators on the other side of the aisle will listen to former deputies attorneys general of the United States, both those who served in Republican administrations and Democratic administrations. Last December, they wrote to the leaders of the Senate. They joined together as Republicans and Democrats and urged the Senate to consider Mr. Cole's nomination without delay. These former officials who served with distinction in that post wrote that the deputy is the chief operating officer of the Department of Justice supervising its day-to-day operations. And the deputy is also a key member of the President's national security team, a function that has grown in importance and complexity in the years since the terror attacks of September 11th. These former deputy attorneys general, Republicans or Democrats alike, were right. Their advice rings true today. And the Senate's treatment of the Cole nomination represents a sharp break from the Senate's long-standing practice of deference to the administration with timely consideration of critical national security and law enforcement nominations. In their letter last December, the 8 former deputy attorneys general noted of the 11 nominations to fill this position over the last 20 years, nominations by both Democratic and Republican presidents, none remained pending for longer than 32 days. Mr. President, I remember some President Bush remained pending even less than that. And last December, after the nomination had already been delayed for over 4 months without any explanation, I came to the floor and I asked unanimous consent that at a time to be determined by the majority and minority leaders, the Senate consent to a time agreement for a debate and a vote on the Cole nomination. Courage to step forward, not hide behind a filibuster, but either vote yes or vote no on this critical national security position. Republicans objected to that request in December. 5 months later, they still refused to agree to a time to debate and vote on the nomination. It's not an ought to vote. American people expect us to vote. Everybody knows the security of this country is threatened. Everybody knows we should stand up and vote. Jim Cole served as a career prosecutor at the Justice Department for 12 years under both Republican and Democratic presidents. He has a well-deserved reputation for fairness, integrity, and especially toughness. He's demonstrated he understands the issues of crime and national security. They're at the center of the Deputy Attorney General's job. Nothing suggests he's going to be anything other than a strong, persistent defender of America's security. So there's no justification for the failure to act on this critical national security nomination, or for failing to make sure that the administration has its full national security team in place. Just as during the time when I was chairman, we moved very, very quickly on President Bush's nominees for Deputy Attorney General, including some, as I said, would not have been, certainly not have been a recommendation I would have made to a Democratic president, but because of the importance for the security of the United States, we want every president to succeed, no matter their party, security. As chairman committee, I move them very, very rapidly. I wish friends on the other side of the aisle allow that with Mr. Cole. So I hope the Senate will reject this destructive, unprecedented filibuster so we can confirm it. So I said I could not remember a time in my 37 years here where we had filibuster, Deputy Attorney General of either presidents of either party. And then we found that we never have, ever, ever. So, Mr. President, before I yield the floor, I have one unanimous consent request for the committee to meet during today's session of the Senate. It has the approval of the majority and minority leaders, and I ask unanimous consent this request be agreed to and the request be printed in the record.
Without objection.
Mr. President, I yield the floor. I see the Senator, distinguished Senator from Texas on the floor, and I yield the floor.
Mr. President.
Senator from Texas.
Mr. President, distinguished chairman of the Judiciary Committee has pointed out that the Deputy Attorney General is a member of the National Security team of the President, and the President has already used the authority under the Constitution to make a recess appointment of this nominee. But the question before the Senate today is whether the Senate should confirm the nomination of James Cole to serve as Deputy Attorney General. There's three reasons why I oppose this nomination. The first is that Mr. Cole is one of the earliest and most vociferous advocates of bringing foreign al-Qaeda terrorists to American cities for civilian trials, a position since repudiated by the Attorney General himself in the case of Khalid Sheikh Mohammed, and I'm grateful for that. But Mr. Cole has never recanted his position that, in effect, these are criminal cases to be prosecuted as ordinary crimes rather than terrorist acts during a time of war. The problem, of course, with the paradigm of treating terrorism as a criminal case is that you don't punish the terrorists until they've actually been successful in committing a terrorist act. And in a war, half the battle, maybe more than half the battle, is trying to stop the terrorist from actually accomplishing his or her goal of killing innocent people. And you do that by interrogating detainees and finding out what they know about the organization and plans of terrorist organizations. And Mr. Cole, unfortunately, stands by the really the outdated, outmoded characterization of these terrorist attacks as if they were ordinary crimes, which they are something much worse indeed. Quite frankly, as Mr. Holder's deputy, Mr. Cole will only exacerbate the worst tendencies of the Department of Justice when it comes to distinguishing between criminal prosecutions and fighting a war against terrorists. This was, of course, the primary reason why Mr. Cole's nomination was unanimously rejected by Judiciary Committee Republicans in the Judiciary Committee. The American people want a Department of Justice that is committed to enforcing the law and protecting the innocent, not creating a new civil rights for terrorists or treating them as ordinary criminals when they are something else indeed. In fact, the recent death of Osama bin Laden was a product of a lot of intelligence gathering that occurred over the years that would never have occurred if Mr. Cole's presumed model of Mirandizing people who are arrested, telling them they don't have to provide any information because they're being treated as ordinary criminals, rather than as terrorists who are eligible for rough interrogation if necessary in order to find out what they know in order to save innocent lives. Rather than listening to the concerns of Republicans on the Judiciary Committee about Mr. Cole's very narrow view of the war on terror and of the views of the American people, and perhaps reconsidering this flawed nomination, the President has decided to plow ahead and bypass the advice and consent process, as of course I said he has the right to do with the recess appointment. There's actually a couple of other reasons why I oppose the nomination. I want to first express my appreciation to Senators Chambliss and Senators Grassley. Senator Chambliss, of course, is the ranking member of the Senate Select Intelligence Committee on Intelligence, and Senator Grassley is the ranking member of the Senate Judiciary Committee. They have continued to demand information from the Department of Justice and have been stonewalled at every turn. Senator Chambliss and his colleagues on the Intelligence Committee have made perfectly reasonable requests consistent with the committee's oversight responsibilities related to the Obama administration's Guantanamo Bay Detainee Review Task Force. Senator Grassley, on the other hand, from his position as the ranking Republican on the Judiciary Committee, on which I serve, has requested documents concerning serious allegations that the Bureau of Alcohol, Tobacco, and Firearms and Explosives knowingly allowed straw purchasers to buy firearms which were then provided to criminal drug cartels in Mexico. It's later been reported that at least 2 of these weapons were later found at the scene where a Border Patrol by the name of Brian Terry was murdered. I fully support Senators Chambliss and Grassley and regret that the repeated requests for information that were well within the purview of the oversight responsibilities of Congress have been unreasonably rejected. Mr. President, when a minority in the Senate is denied the usual and customary information that's necessary for us to do our job, we are left with very few options. But one of those options is to force resolution by exercising our rights as a minority to block cloture. That's not necessarily a permanent move. It means debate continues on the nomination and you can't come to a vote. But I would submit that if rational minds would come together on this, Senator Grassley, Senator Chambliss could get the information that they and their committees are entitled to and discharge their oversight responsibilities, and we could come much closer to resolving the differences on this particular nominee. Mr. President, I yield the floor and I suggest the absence of quorum.
Clerk will call the roll.
Mr. Akaka.